Too, so we'll go ahead and get the show on the road. Welcome everyone to this informative webinar for an update on the changes to the Patient Act. I'm Susie Keller. I'm the CEO of the Idaho Medical Association and happy to partner with Holland and Hart, our speaker Kim Stanger, along with the Idaho Hospital Association and the Idaho Medical Group Management Association. So we are very pleased to have all of these partners here today. And I'll just tee up why we are talking about changes to the Idaho Patient Act. I think you all are very aware of the original law that passed in 2020 and went into effect in 2021. And you all, the practice managers, and those folks who were on the ground were the ones who really informed this process and helped point out several problems with the Idaho Patient Act. And through the good work and advocacy of a lot of healthcare provider groups, we were able to work with the original sponsors of the legislation to make some changes. Throughout that process, you told us, hey, it's costing us a lot of money to change our software to put the insurance group and member numbers on the patient's final notice. You said the Patient Act, as it used to be, was preventing you from taking immediate action on bounce checks. There are some insurance issues that were also problems. Fortunately, we were all able to work together to make some changes to the law that ended up being House Bill 778 that passed. So we're very lucky today to have Kim Stanger, a very experienced healthcare attorney who provides great advice and guidance to healthcare providers across Idaho, who's going to walk through some of those changes and what you need to know in order to comply, which we hope will be a lot easier now. And so with that, Kim, I will turn it over to you.
Thank you, Susie. Initially, kudos to IMA, IHA, and the others who were able to secure changes to the Act. Obviously, they weren't all the changes that everybody would have hoped for, but given the circumstances, they did an admirable job in getting it better where it was. Okay, so this is what I wanted to talk about today. I'm going to give you just a quick brief summary of the changes that occurred to the Idaho Patient Act, and then I'm going to review the Idaho Patient Act, the requirements, and discuss those changes in context. In the slides today, hopefully you've received a copy of the slides. In the slides today in red, I've identified the amendments so that when we're talking about the changes, you can, or talking about implementing the Act, you can see the changes. I'm hoping to have some time at the end to address questions that you might have, but if not, if we run short on time, if you want to use that chat feature, you can go ahead and send those to me and I can answer offline, or you can just shoot me an email. I'm very glad to have Susie and Jamie on the line, and they can certainly chime in with their thoughts as well as give us a better perspective of kind of everything that was going on behind the scenes. Because quite frankly, the language within the Act is not very good. We did everything that we could to try to get it better, but unfortunately, you can't always control the legislators. And so there's some ambiguity, some provisions in the Act, and Jamie and Susie may be able to give us some insight as to kind of what the intent was. You should have received the link for written materials, including a copy of the PowerPoint slides. I did modify some of those slides as I was preparing this morning, and so if you're looking for the slides that, or looking at the slides that you got yesterday, you may want to update them with the new slides that came out. Those are on our website, or you should have them through the link. In addition, we've made available to you a copy of the actual amendments themselves, so you can see the red line version that shows the changes to the original Act. We've also provided you with the IMA's very helpful summary of those changes, as well as an article that I wrote dealing with those changes. Again, if you didn't receive those, just shoot me or Charles Cobbins an email at Holland and Hart. We'll make sure that you get those. All right, with that said, let's talk about the Idaho Patient Act and its amendments. As you know, for those of you who may have been under a rock and haven't heard this, the Idaho Patient Act has been in force for over a year now. The general rule is that before pursuing an extraordinary collection action or an ECA against patients, the providers must timely submit the claims to the patients or the patient's payers, those who are identified by the patient. They've also got to timely send a the patient's a consolidated summary of service unless they are accepted from that requirement. And the exception is pretty broad. And they've got to provide a final notice before an extraordinary collection action. This was formerly known as the final statement. It's been rebranded as the final notice before an extraordinary collection action. If you fail to do so, you may limit your ability to pursue an ECA. It could also prevent you, or will prevent you, from recovering your costs, expenses, and fees associated with the collection, and or it could expose you to certain statutory penalties. In the amendments that occurred, they took effect actually when Governor Little signed it, so on March 25th, 22. They apply to extraordinary collection actions that take place or are initiated after that March 25th deadline. The amendments include the following. They extend the time and provides flexibility to providers in submitting the claims and, if required, the consolidated summary of services consistent with national billing standards and particularly the global service codes. It renames the final statement to the final notice before extraordinary collection action, so it gives you a little bit better view, or more accurately describes that notice that goes out. It allows providers to change the consolidated summary as well as the final notice, but make sure you're aware of the effect that those changes may have on the deadlines. I'll talk more about that in just a minute. It confirms that the waiting period for the extraordinary collection action runs from the later of a compliant CSS or final notice. It confirms that you're not required to include the patient's group number and member number in the final notice, so long as you submitted the claim to the correct payer. It extends the grace period for patients' receipt of the consolidated summary, consolidated statement to 180 days or 240 days total, so it gives you more time if you fail to submit that timely. But there are consequences. If you do take that additional time, it's going to result in a waiver of your ability to obtain costs, expenses, and fees. It allows providers to act immediately on bounce checks without having to wait for the time limits that otherwise apply to ECAs. It also shortens the time to report patients to credit agencies to 45 days, from 90 days to 45 days, if you satisfy certain conditions. But by doing so, you forfeit your right to file a lawsuit or related lien, attachment, or garnishment, etc. And if you are going to pursue a complaint in an ECA, then that complaint has to include certain specified information. So that's a quick summary of the amendments. Let's put those in context now by talking about how the Act applies. First thing to note is the Act applies to all healthcare providers, which is defined to include a physician or other healthcare practitioner or any agent or third-party representative thereof. So it could include not only your practice, but to the extent that you engage a collection action to act on your behalf as your representative, then the Act would also apply to those other entities who are acting on your behalf. It also applies to a health care facility. Now, healthcare facility is defined as any person, entity, or institution operating a physical or virtual location that holds itself out as providing healthcare services. So it's pretty much going to apply to all healthcare providers, whether you're an individual, whether you're an institutional healthcare provider. One item of interest that may become important down the road, and we'll talk a little bit more about it later, is note that a healthcare facility is not just an entity, some institution out there. It's also can mean any particular person. We'll talk more about the potential significance of that later. The Patient Act applies to the debt of a patient, which includes not only the patient themselves, but also the parent of a minor patient, a legal guardian, or any person contractually or otherwise liable for the financial obligations of the person receiving the goods or services from the healthcare provider. The net result there is it not only applies to your attempts to collect the debt from the patient themselves, but also anybody who is contractually or otherwise liable for the obligations of the patients. It applies to any person bringing an extraordinary collection agent action. It's not just the healthcare provider who brings that, but it applies to any other person, including third-party collection agencies who may be pursuing that on their own behalf. Now, the Act only applies to extraordinary collection actions. This is really the guts of the Act, which you need to understand. An extraordinary collection action is defined as any of the following in conjunction with the patient's death. The amendments didn't change a lot of this other than clarifying one aspect that I'll talk about in a minute. But just as in the past, an extraordinary collection action is any of the following actions. If prior to 60 days from the patient's receipt of the final notice, it's the selling, transferring, and assigning a patient's debt to any third party or otherwise authorizing any third party to collect the debt in a name other than the name of the healthcare provider. So this is a situation where you're actually assigning that right to collect the debt to that collection agency. It's not when you're just retaining a collection agency to help you collect in your own name. It's when you're selling that debt to a third party. It also applies to reporting adverse information about a patient to a consumer reporting agency. And remember, the patient is defined broadly to not only include the patient, but others who are liable for that debt. It also includes the commencing any judicial or legal action or filing or recording any document in relation thereto, including but not limited to placing a lien on a person's property or assets, attaching or seizing a person's bank account or any other personal property, or initiating a civil action against any person or garnishing an individual's wages. So that's what the Patient Act applies to. It only applies to those specific actions to collect on the patient's debt. Now, in the amendments, they confirmed that it does not, an ECA does not include an action in response to a bad check so long as you comply with the requirements that are otherwise set forth in the statute for acting on bad checks. Those requirements are set forth in Idaho Code 28-22-105. The net result of this is you're not required to wait to go after a patient if they pass a bad check. Instead, as long as you comply with those statutory requirements that currently exist for addressing bad checks, then you don't have to wait. You can go after them immediately. Those statutes in generally state that if you gave prior notice or have an agreement with the patient, for example, the patient comes in and you have them sign your financial services arrangement that confirms that you can collect a $20 fee plus the cost of collection if the patient passes a bad check, then you can go ahead and take action immediately. On the other hand, if there isn't that prior notice or that agreement with the patient, then you can still go after them, but you have to jump through a couple of hoops. You have to send a notice that's required by 28-22-104. That statute has a specific notice that you send to the patient. And you have to give the patient 15 days to pay the check. And if the patient fails to pay the check, then you may collect a $20 fee plus the cost of collection. So this gives you an avenue for at least those patients who pass a bad check. You don't have to wait. You can go after them immediately. In addition, remember that the statute only applies to those certain ECAs, right? If you're going to take action that is not within those defined ECAs, not in any of these particular actions that are set forth in the statute, you can still take action that's not governed by the Idaho Patient Act. There's actually a section of the Patient Act that says that it's not intended to address any other collection efforts that are outside the definition of an extraordinary collection action. So, for example, you may engage in your own self-help. For example, you may send bills or letters demanding payment to the patient. You may discharge the patient from their practice if they fail to pay. Now, remember, you may have patient abandonment issues if you do that, but under the Idaho Patient Act, it doesn't prohibit you from doing that. You could contact guarantors or others with responsibility for the payment. You can reach out to them and try to get payment on your own behalf. Again, you may have to be concerned about HIPAA issues, but remember, HIPAA, under the payment exception, generally allows you to contact others in order to secure payment for the services that were rendered. Or perhaps other action. The key there is you're taking action yourself. You're not initiating any of those kind of third-party extraordinary collection efforts. You may also engage a third party to help you collect the debt so long as that third party is acting on your behalf. You haven't sold the account to somebody else. Instead, you're just hiring them to come in there and help you collect your own debt. So the debt is in your name. You're collecting on your own debt. You haven't transferred it to somebody else. You may send to a third-party collection agency 60 days after the final notice, because remember, under the definition of an extraordinary collection action, it only applies if prior to 60 days from the patient's receipt of the final notice that you sell or transfer to the collection agency. So if you wait for that 60 days after the final notice, you can go ahead and send it, sell it to the collection agency. And you may pursue an extraordinary collection action if you, even though you don't otherwise comply. But if you do, you cannot recover your costs, expenses, and fees, and you may be subject to penalties of $1,000 to $3,000 plus damages. And we'll talk more about that in just a minute. So let's talk about what you need to do in order to comply with the Act in order to pursue an extraordinary collection action. So to pursue the ECA, the first thing you've got to do is you've got to submit the charges to the third-party payers, including multiple payers identified by the patient. This was one of the amendments. It allows the patient to not only identify one third-party payer, but any third-party payers that they want you to send the information to. They can identify that, and then you're generally obligated to send that those claims to those payers that are identified by the patient, or if the patient does not identify a third-party payer, then you would go ahead and submit those charges to the patient. Here's the key. You've got to do that within 45 days of the later of the following. So you'll look down and you calendar from the later of the following. Either the provision of goods or services to the patient, or the date of discharge from a healthcare facility, or the first date permitted by applicable billing codes, policies, or procedures as published by the relevant national association. That third one was added by the amendments, and this is a very important addition because it allows you to take advantage of certain situations or accommodate certain situations where maybe you have global fees or you have other situations where you can't submit the claims individually. You've got to wait for the global fee, and then you have to submit the claim at the end of the services or something like that, which may be otherwise outside that 45-day window. So this is an important addition, and gives you some additional time if there's national guidance, billing guidance that directs you to wait before you can go ahead and submit those services to the appropriate payers. Now, just as in the original Act, the amendments confirm that to pursue the extraordinary collection action, you may take an additional 45 days in order to submit those claims to the payers or the patient, so a total of up to 90 days. But if you take that additional time period beyond the original 45 days, if you submit it between 45 and 90 days, then you can still pursue the collection action, but you cannot recover your costs, expenses, and fees, including attorney's fees, but you'd still be able to recover the principal debt. So it does give you that additional 45-day window, but you're not going to want to take that if you don't have to, because you're not going to be able to recover the additional collection costs associated with that. So you want to always try to fit within that original first 45-day window. When you submit those charges, make sure that you're documenting, calendaring, and monitoring that 45-day deadline in order to submit the claim so you don't accidentally blow that, because that'll limit your ability to get those additional fees, and maybe limit your ability to send those off to a third-party collection agency. You want to document the third-party payers who are identified by the patients because, as we'll talk about a little bit later on, you need to prove that you submitted those to the right payers. You're going to want to document the submission to the payers, including the payers to whom the claim was submitted and the date of submissions. We'll talk about that later on, why you need to do that. And you need to document the relevant National Association billing policies if those would allow you to go beyond, if those are applicable, so it basically would toll that time for submitting that claim. You want to make sure that you document that so that you can justify your action if it ever comes up in the future in the case of litigation, because you're going to have the burden of proof of establishing your compliance with the rules. Okay, so that's the first thing you do. That's one of the most important things. You've got to timely submit the claim to the payers or the patient. The next thing is, if you are, unless you fit within an exception, you have to submit this Consolidated Summary of Services, or the CSS. So you've got to submit it in a time such that the patient receives the Consolidated Summary of Services from the healthcare facility, unless you fit within the exception, and they've got to receive that within 60 days of the later of, again, the provision of goods or services to the patient, the date of discharge from a healthcare facility, or the first date permitted by the applicable billing codes, policies, or procedures as published by the relevant national association. So you've got that initial 60-day window in order to submit that CSS. In the amendments, they actually extended the deadline for doing that. You have an additional grace period of additional 180 days instead of the shorter grace period that existed before. So now you've got an additional 180 days up to a total of 240 days in order to submit that CSS. But if you take that additional time from 60 days to 240 days, then you're not going to be able to recover your costs, expenses, and fees, including your attorney's fees. So once more, you're going to want to try to submit that consolidated summary within 60 days after the time the services were provided, the patient was discharged from the healthcare facility, or the date you were first permitted to submit the claims according to national billing standards. Now, you only have to do the CSS if you don't fit within the exception. So what's the exception? A CSS is not required if you satisfy the following. If the patient receives a final notice from a single billing entity for all goods and services provided to the patient at that health facility, the patient was clearly informed in writing of the name, phone number, and address of the billing entity, and the healthcare facility complies with all the other provisions of the Patient Act, including the charges were submitted within the 45 or 90-day period. You sent the final notice and you waited to charge interest or pursue interest or additional fees or pursue the action for the required time period. So what does this mean? This means that if you are a private physician practice and you're not billing for anybody else, or no other services were provided by an outside entity at your practice, then you don't need to worry about a consolidated summary of services. It really only applies in those situations where the services are provided at a healthcare facility, which is like a hospital or an ASC, where there would be multiple bills from different providers for the services that were rendered at that facility. If you're the only one that provides the bill, the patient's only going to get one bill for the services that were provided at your facility or at your practice, then you don't need to worry about the consolidated summary of services. This is really important, so make sure that you understand that so that you know when you do and do not have to provide that consolidated summary of services. If you are a healthcare facility that must submit that consolidated summary of services because more other providers are going to be billing for services rendered at your facility, then your CSS must include the following. These have not changed from the original rule, so it's still the same stuff you've had to do for over the year now. You've got to include that statement stating that this is not a bill, this is a summary of medical services you received, it's so forth, it's so forth. That's prescribed by the statute. You've got to include the patient's name, phone, and contact information, the facility's name, phone, and contact information, the date and duration of the patient's visit to the facility, and a general description of the items provided to the patient, including the name, address, phone number of each billing entity whose providers rendered items to the patient. Now, here is an important change. It may be a situation where you get additional information along the process so that your original consolidated summary of services was not accurate or was not complete. The situation's changed or you got additional information. The amendments allow you to submit a new consolidated summary of services. So if there are multiple consolidated summaries of services due to the changes, then for purposes of calculating that 60/240 day deadline, you use the first consolidated summary that supplied the required information, assuming that the information did not change in the subsequent CSS. So for purposes of calculating that 60/240 day deadline, you would look at the first CSS that contained all the information that you're required to have. So if it changed, you would look at the one that changed to include all the information you required. And that's the one you use for calculating that 60/240 day deadline. If it subsequently changes, then you would use the later one. So you need to make sure that you're using the right CSS for calculating that 60/240 day deadline. Now, this is important. Make sure that when you're submitting that, that you're still considering that 60/240 day deadline. I think that there's some ambiguity in the statute that I think the intent was is that this was, if you do submit a new consolidated summary of services, that would restart that 60/240 day deadline. I'm not sure that's exactly the way the statute's written. So if you really want to be safe, you still want to make sure that those changes are made and submitted still within that 60/240 day deadline, or at least until we get further clarification on those particular issues. Now note that those deadlines, that 60/240 day deadline for the CSS, runs from the time that the patient receives the CSS and later on the final notice, not when they're sent. Now that's not a change. That's been around for since the beginning of the Idaho Patient Act. But just make sure that you realize that if you're sending that out, you have to calculate or factor in the time that it's going to take to get to the patient, because the patient has to receive that within that 60/240 day window. The statute states that a patient is presumed to have received the CSS and final notice 3 days after they were sent by first-class mail to the patient's address, as confirmed by the patient during the last visit, or as updated by the patient in a subsequent written or electronic communication. So you're going to want to make sure that you document that you sent that CSS and or final notice to the patient at the address that they confirmed during their last visit, or at subsequent, if the patient told you a different address later on, you're going to want to confirm that you sent it to that appropriate address. It needs to go to the right address. Otherwise, you would have to establish that the patient actually received it. Now, the patient may agree in writing to receive the CSS or final notice via email or other electronic means. So if the patient says, yeah, you can send it to, we can send it via the portal or send it via email or text. By the way, you need to comply with HIPAA for those. But as long as you're doing that, the patient's agreed in writing that you can do that, then you can send it by those means. Now, the statute does not require you to send it by first-class mail, but if you're not going to send it by first-class mail, then you're not going to get the benefit of this presumption. You would still have to come in there and prove that you sent it and that the patient received it. All right, so that's the second thing you need to do. If you are a healthcare facility at which other providers are rendering services for which they are going to bill separately, you need to send that CSS. In addition, you've got to send the final notice before the extraordinary collection action. This is what used to be known as the final statement. They've renamed it to more accurately reflect what it's intended to be, which is the final notice before you engage in that extraordinary collection action. So you've got to provide that final notice before you can engage in the extraordinary collection actions. In addition, if you're going to charge interest or other fees, you've got to wait at least 60 days after the patient receives that final notice or the consolidated summary, whichever is later. So when you're calculating that 60-day window in order to begin charging interest, it runs from the later of either the financial notice or the CSS if you had to produce that CSS. That's a change in the amendment. They added that language about the CSS, whichever is later. So make sure that you update your policies or procedures if you're a healthcare facility. Make sure that you understand that that waiting period to charge interest and fees runs from the later of the receipt of the final notice or the CSS. In addition, now that's just to be able to allow you to charge interest or other fees, but if you want to pursue an ECA, you've got to wait at least 90 days after the patient receives that financial notice or CSS, whichever is later, and that there's been a final resolution of the internal reviews, disputes, and appeals of charges or payer obligations or payments. So you've not only got to wait for the 90 days to run from the time that the patient received it, but all these other issues have been resolved. Okay. Now, unlike the submission of claims or the CSS, there is no deadline for actually submitting the final notice. You can wait as long as you want in order to submit the final notice, right? So you can wait till you get all of those things resolved before you send that final notice. That's really what the intent is. The clock starts running, though, there's a waiting period after you send that final notice before you can engage in those extraordinary collection actions. Now, as amended, there is an exception. Under this exception, that 90-day window to initiate the extraordinary collection actions is shortened to 45 days to report to credit agency if you satisfy certain conditions. So the way that it works is if you don't want to wait for the full 90 days, you want to go ahead and just report that patient to a credit agency right now because you think that's your biggest leverage for getting paid, then the regulation or the new statute says, as amended, you only have to wait 45 days to report to the consumer reporting agency if you do the following. At least 30 days before you make that report, the patient has to receive a written notice that you intend to make that report. And in addition, if you are going to make that report prior to the 90 days, so then you're going to be prohibited from commencing a lawsuit or recording any document relating to that notice. So yeah, you can go ahead and make this report to the consumer reporting agency after 45 days, so long as you gave that notice. But if you're going to do that, you're not going to be able to pursue a lawsuit in order to collect on that account. Or at least if you do, then you could be subject to penalties and other limitations. So yes, you do have that right to give the report after 45 days, but there are strings attached to that and there are costs associated with that. So just make sure that you balance that before deciding to go down that path. Just like the CSS, if there are multiple final notices, you calculate the deadlines using the first financial notice that supplied the required information if such information did not change in the subsequent financial notices. So you can make changes to the final notice. Just make sure that you realize and you factor in the deadlines when you're making that notice. It's probably not much of an issue for the final notice because remember, the waiting period runs from that amended final notice. When you submit that final notice, the final notice has to contain the following: the patient's name and phone and contact information, the facility's name, phone, and contact information, the list of goods and services provided, including the initial charges and the dates provided, the statement that a full itemized list of goods and services is provided to the patient is available on the patient's request, the name of third-party payers to which the charges were submitted, the detailed description of reductions, adjustments, offsets, and payments that have been received, the final net amount that the patient is liable to pay, taking into account all reductions, adjustments, or offsets or payments. Now, as originally promulgated, I think that the final notice also had to contain the patient's group and membership number, but that has been changed. The amendment took that out, so you no longer have to include that in your final notice, but there are consequences if you don't. As amended, the statute now says that to pursue an extraordinary collection action, you've got to ensure that the provider either submitted all the charges to the correct third-party payer, or your final notice has to include the name of the third-party payer to which the charges were submitted. In addition, it's got to have the patient's group number, and it's got to have the last 4 digits of the patient's membership number. So you got to satisfy one of these two things in order to bring that ECA. You got to make sure either the charges were submitted to the correct payer, in which case you would have the burden of proof of establishing that, or you've got to make sure, if you don't want that burden of proof, you're not sure you submitted it to the right payer, then you're going to want to include in that final notice this additional information, including the patient's group number and the last 4 digits of the patient's membership number. All right, that is a brief summary of the requirements of the Idaho Patient Act. If you comply with those requirements, you can go ahead and pursue the extraordinary collection action and recover the principal. You can also recover the costs, expenses, and fees that are subject, obviously subject to any agreement that you may have had with the patient, as well as any applicable laws limiting the amount that you may recover. But under the Idaho Patient Act, it's going to limit the amount of fees that you can actually recover from the patient. We'll talk about that in just a minute. On the other hand, if you violate the Idaho Patient Act, you still may be able to recover the principal. That appears to be the intent, although the statute is a little bit weird because 48-304 says you can't even pursue an extraordinary collection action unless you comply with that. And then it goes on to say the penalties if you do pursue it. So there's a little bit of a disconnect there. I think that the intent certainly is that you still could pursue it, but you just could be subject to penalties, but you could still recover the principal, if not the additional fees. So if you violate the act, you may be able to recover the principals, but you cannot recover the costs, expenses, or fees for an extraordinary collection action, which of course limits your ability perhaps to transfer this debt to a third-party collection agency, or certainly minimizes the attractiveness of entering into those debt collection proceedings. And you also may be subject to additional penalties that we'll talk about in just a minute. Remember that as you as the provider, you've got the burden of proving that you complied with the Idaho Patient Act. The statute specifically says that you have the burden of proving that you timely submitted the claims, you timely submitted the CSS unless it was accepted, and that you've submitted an appropriate financial notice and waited the appropriate time period before you pursued the extraordinary collection action. The statute goes on to say that if you are going to sue the patient, bring an action, a collection action against the patient, that complaint must plead with particularity the compliance with each of the requirements. In your complaint, you have to certify or verify that you satisfied each of those requirements under the Idaho Patient Act. In addition, as amended, the statute states that that complaint has to identify the name, group, and policy numbers of third-party payers to which the claims were submitted and the dates of each submission. So that's part of the pleading that you're going to have to make if you're going to pursue one of these actions. Well, if you pursue the actions, what are the fees that you can recover? Well, the Idaho Patient Act capped the amount of fees that you can recover. If it's an uncontested judgment, meaning that the patient doesn't contest that yeah, I owe the money and yeah, I've got to pay. If it's uncontested, then the provider can recover the principal plus up to the lesser of $350 or 100% of the principal plus pre and post judgment interest, consistent with the amount that you can charge under 48-304, meaning that you have to wait for the 60-day period before you can begin accruing interest. So if it's an uncontested judgment, you can only recover the principal plus these additional fees. On the other hand, if it's a contested judgment where the patient bites you on it and you win, you can recover the principal plus up to the lesser of $700 or 100% of the principal plus pre and post judgment interest. If you have to engage in post judgment writs or motions in order to collect that, because the patient's not going to pay you and you have to bring an act for a garnishment or an attachment or those types of things, you can get up to $75 or $25 per successful motion or writ, plus you can get service fees according to the county. If it's a contested judgment and these fees don't adequately compensate you, then the statute does allow an avenue for you to collect more. If the costs and expenses and fees are grossly disproportionate to the amounts set forth above, so the caps on the fees really don't represent what's fair, and you've got to establish that the patient willfully attempted to avoid paying a bona fide debt. So they knew what they were doing and they were just out there dodging it. On the other hand, if the patient wins, there are no caps on the costs and fees that the patient recovered. The statute says that the patient may recover all costs, expenses, and fees incurred by the patient, including their attorney's fees, and it confirms that the patient has no liability for pre-judgment interest, costs, expenses, or fees, including attorney's fees. Now, it doesn't say that the patient doesn't have to pay the principal, but if the patient wins, then presumably they're not obligated to pay any of the principal amount either. Now, even if you win, if you violated the Idaho Patient Act, you can still get hit up with statutory penalties. This is the stick that they use in order to make sure that you're going to comply. So if you bring an extraordinary collection action like a lawsuit or otherwise, without complying with the Idaho Patient Act requirements, then the patient has no liability for the collection costs, expenses, and fees. Now, the statute doesn't say they're not responsible for the principal, but they have no liability for collection costs, expenses, and fees. It doesn't matter what else you put in your agreement with them. this trumps any agreement you had with them. So they're not going to have to pay the fees. In addition, the provider is liable to the patient for the greater of $1,000 or the damages suffered by the patient due to violation. So you may have to pay the patient $1,000. You may get the principal amount, but you got to pay $1,000 of that back to the patient. Or if the provider willfully or knowingly violated the statute, then the court may award the greater of $3,000 or treble damages suffered by the patient due to the violation. In addition, the patient is entitled to the cost plus reasonable attorney's fees. So you need to make sure that you comply with the Idaho Patient Act if you can, otherwise you can get hit up with those penalties. So to briefly summarize, I was asked to provide some kind of a timeline. I'm not sure whether this timeline makes sense to you, but I'll kind of walk through because it may be helpful. To bring an extraordinary collection action, then you've got to do three things. You've got to submit the claim. You've got to, the patient has to receive a consolidated summary of services if that's required for your particular healthcare facility, and the patient has to receive a final notice before the ACA. Let's talk about each of those. The time period for submitting the claim to the payers or the patient, and the time period for the patient receiving the CSS runs from this point. It runs from the latest of the date the services were provided, or the date the patient was discharged from the facility, or the first date that you were permitted by national billing standards in order to submit those claims. So to submit the claim to the payers of the patient, you start at that point and you've got 45 days in order to submit those claims to the payers or the patient. You can take an additional 45 days, so up to a total of 90 days, but for that additional time period, you're not going to be able to recover the fees and the costs. If you're required to submit the CSS, again, you've got to submit that within that initial time period from the latest of the date the services were provided, or the date of discharge from the healthcare facility, or the first date that you're permitted to by national billing standards to submit that. From that point, you've got 60 days in order to submit that CSS. You can take an additional 180 days, so up to 240 days total. But if you're going to take that additional grace period, you're not going to be able to recover your costs and fees associated with collection. Now, so you've got to do those two things. In addition to that, you've also got to provide or make sure that the patient receives that final notice before you initiating that extraordinary collection action. And you've got to make sure, if you're going to do that, that the claims were submitted to the correct payer, or that your final notice includes the payer's name plus the patient's group number plus the last four digits of the patient's membership number. So either one of those. So you got to submit the final notice, and you've either got to submit that claim to the right payer, or your final notice has to contain this additional information. Now, you don't have a deadline for initiating that final notice, but you've got to wait after initiating that final notice before you can engage in that extraordinary collection action. So you've got to wait after you give that final notice from the later of the final notice or the CSS, if that's required, whichever is later, and the final resolution of the claims, reviews, disputes, and appeals. From that point, the clock starts ticking. You've got to wait at least 90 days in order to initiate that extraordinary collection action. Now, remember, there is that exception that if you want to, you can wait 45 days and then you can report them to the credit reporting agency. But if you're going to do that, you're essentially forfeiting your right to bring a lawsuit in order to pursue that extraordinary collection action. So hopefully that chart makes some sense for you. All right, let's talk just briefly about some common problems or issues that are still lurking out there. One is the effect of this on the Idaho medical lien statute. As you may know, Idaho has a lien statute that allows providers, hospitals to go ahead and file a lien against a tortfeasor. That lien is against any recovery that that tortfeasor may owe to the patient in order to cover their medical bills. Now, in order to perfect that lien, you've got to wait 90 days, or that's got to be filed within 90 days after the last date of treatment or discharge. Well, the problem is under the Idaho Patient Act, you've got to wait 90 days before you can file the lien. But this says you've got to file the lien within that 90-day period in order to get the benefit to perfect the lien statute. So there's kind of this disconnect here. I think that there are arguments why the Idaho Patient Act would not apply there, but unfortunately, I understand that there's a case, a District of Idaho case that's come out that said that that the Idaho Patient Act trumps that lien statute. The bottom line here is that the IMA is looking at this, they're trying to resolve that, and we hope that they will be able to resolve that in future changes to the Patient Act or revisions in the Idaho Medical Lien Statute. I get questions about, well, how does the Idaho Patient Act relate to the no surprise billing rule? Because under the federal no surprise billing rule, remember, you've got to give that good faith estimate, and you can be, that good faith estimate is going to limit the amount of charges that you can make to the patient. The bottom line there is they don't really overlap. They're two different laws. You got to comply with both of them. The no surprise billing rule in general, for most of you, just applies to the good faith estimate that you give to self-pay patients in advance. The Idaho Patient Act applies to the amount that, your collection actions against the patient after the services have been rendered. So there's not really much overlap. They do not conflict. I get questions about, HIPAA privacy concerns, because under the Idaho Patient Act, it requires you to disclose certain information, including the name, group number, and policy number on any complaint that's filed. Well, the gist of that, the short of that is, remember, under HIPAA, you can use or disclose protected health information for purposes of treatment and payment, which includes collections, so long as you use the minimum necessary. Well, if you've got an Idaho statute like the Idaho Patient Act that says that you must provide this particular information, then that's probably the minimum necessary, and you're probably going to be okay for HIPAA if you include that information in the complaint, even if it's published, even if it's filed in a matter of public record. Some other common questions. What if the patient has ongoing care? Can we wait until care is finished in order to submit that? Generally, yes, subject to some concerns. Remember, you've got to submit the claim within the 45 days after the care is rendered. But remember, it runs from the latest of the date that the services were provided or the date of discharge from the facility. Interestingly enough, remember that the healthcare facility is defined as any person or other institution. So one could argue, if you're even a physician practice and you're continuing to provide care from the patient, then that date of discharge, that discharge hasn't occurred until they're discharged from that particular episode of care. So there may be a way to kind of string out that deadline in order to do that. But generally, if you want to be safe, you want to go ahead and file those claims within 45 days after the date the services were provided, or if you're in a healthcare facility from the date of discharge, unless you fit within one of those situations where you have national billing standards that says that you have to wait in order to that. Next question, what if the patient fails to identify a payer? You go through this process only to find out later that some payers popped up and you didn't know about them and you never submitted the claim. Well, under the Idaho Patient Act, you only have to submit to payers that are identified by the patient. So if the patient didn't identify the payer, it's not a violation of the Patient Act if you didn't submit the claim. What if we learned that the payer to whom we submitted the claim is secondary and we must submit the claim to another payer? Well, again, you only have to submit the claims to the payers that were identified by the patient. So if the patient didn't identify that primary payer, then you're not going to violate the Patient Act. But you want to make sure that you've documented those designations by the patient of the appropriate payers. Next question, must we include the names of other providers who will bill for their services on our CSS or final notice? It depends on your particular situation. If you've got if you're a healthcare facility where other providers are rendering services and they're going to bill for services that they provided at your facility, then you generally do have to list those other entities. On the other hand, if you are a group practice or other entity where you are the only entity billing for the services that are rendered, then you don't have to list other providers, even though you know other providers are going to be providing services. So it's different than the forthcoming good faith estimate rules in that regard. Must we include anticipated future services on our CSS or final notice? No, you only have to disclose those services that are rendered. Remember, the whole goal of this is to identify the amount of debt that the patient has And that's, of course, only incurred, that debt is incurred based on the services that were actually provided. What if the CSS and or the final notice are returned as undeliverable? Well, that raises an interesting question because remember the statute says that those deadlines run from the time that the patient received the CSS or final notice. But it also creates that presumption that if you send it by first-class mail to the address that the patient identified during their last visit, or they subsequently notified you in another electronic or written communication, as long as you send it to that, then the patient is presumed to have received it. So whether or not they received it, I suppose, you get the benefit of that statutory assumption. If it's returned, though, and you did not send it by first-class mail to those appropriate places, then that could create an issue for you. So you're going to want to make sure that you document the patient's actual receipt, or you're going to want to use that first-class mail option to get the benefit of that presumption that they received it. All right, those are some of the common questions that I've gotten along the way. Susie, I'll turn it back to you. I'm not sure, let's see, it looks like we've got a few minutes if you want to field any more questions, or if you want to come in with any additional insights concerning the negotiations or other things that are going on with this, I turn it back to you.
Wonderful. Thank you. Great job, Kim. We very much appreciate it. If you have questions, please put them into the Q&A and we'll address those. And while we're waiting on that, I just want to emphasize the reason we were able to make these questions and changes available on the Patient Act was because of the practice managers and the physicians who brought these to our attention. So that really emphasizes the importance of membership in the IMA, in IMGMA, the Idaho Hospital Association. We can't do this work without your support. So just a plug to please keep supporting our organizations through your membership and encourage your colleagues to join as well. So here is a question regarding slide 20 for the CSX exemption. How do you recommend the patient receives, provider provides the writing with the billing entity information?
Let me go back to slide 20 if I can find it here.
Yes.
All right, there it is. And I'm sorry, what was the question there?
So I think it's with respect to a single billing entity that is exempted from providing a CSS. I
Right.
said, the question is, how do you recommend that they provide the writing with the billing entity information?
Well, that's part of the elements of a final notice, right? That's going to have to be there. But presumably, when you've sent them bills, otherwise throughout the process, right? You don't have to wait to send any bills to them. You just got to send a final notice. But presumably, they've received bills along the way with the billing information. So either you could use those bills, you could use the maybe have the patient sign something as part of your financial services when they initially come into your office. They're going to receive sign some kind of financial services agreement, or you include it in your final notice. I think any of those options would satisfy. The main thing is just making sure you've got something in writing that shows that they got that information of the billing entity.
Yep. Okay, another question. Are there any lobbying efforts to get an exemption for nonprofit hospitals that already have to comply with ACA regs that have overlapping ECA requirements? I can speak to the lobbying efforts, and I believe Kim referred to this as well. With your help, practice managers and others, experts on the ground, you identified clearly over a dozen specific issues and problems that the Idaho Patient Act created when it landed in our laps. And we narrowed our dozens of issues down to about 5 or 6 that we were ultimately able to negotiate on. And part of that, the legislature agreed to help us with that with an unwritten, unspoken agreement that we wouldn't be coming back to the legislature every single year and asking for more changes and tweaks to the Idaho Patient Act. So The short-term answer to your question about lobbying efforts exempting nonprofit hospitals, probably not. Unfortunately, we know it's still burdensome for facilities and providers to comply with IPACT, but no efforts will be ongoing in the near term. Another question. In order to add interest to outstanding patient accounts, is a final notice required to be sent? Um, I I believe it is. So Kim, can you verify that?
Uh, yeah, as part of the requirements in that final notice, right? You've got to wait for 60 days after the final notice before you can begin to accrue interest. And so you would have to give the final notice that would trigger the time in order to charge the interest. That raises interesting questions about the retroactive date of the statute and all of those types of things that we really didn't get into today. But generally you would have to have some kind of an agreement in order to charge interest, unless you're going to get prejudgment interest. But the bottom line is, make sure your patient agreements specify the interest that they're going to have to pay. Make sure that your practices are consistent, that you toll or don't accrue that interest until it doesn't begin accruing until 60 days after that final notice is received.
Okay, and we have another question here, and I'm going to go ahead and call this as the last question. And it's with respect to patients that don't always provide accurate contact information intentionally. It's my understanding that if you can document the information that the patient gave to you at the time, that is supposed to cover you. But the question is, in those situations, and there are actually two separate situations that are being asked about. In the case of the patient intentionally providing incorrect information that is written down, or in the instance of somebody making a mistake when they write it down. So the question is, how do we, does the presumption still apply?
Yeah, I think so. I haven't seen any cases discussing this, and Susie, you may have a better perspective on kind of what the negotiations were, but the statute says that they're presumed to have received it if it was sent to the first class mail to the patient's address as confirmed by the patient during the last visit. So at the last visit, if you confirmed with the patient that this is the proper address and you documented that, then you should be entitled to that presumption, assuming you sent it by the first class mail. So I don't particularly care for compliance here. If the patient lied to you, you're not limited by the patient's lying, at least according to the Idaho Patient Act, as long as you send it to the place that they said they were living. Then you should get the benefit of that presumption. Now, whether or not you can collect from the patient is a whole other thing if you can't track them down. But as far as getting the benefit for the presumption, you should be fine.
Right. And that's a good point, because the practice managers who are helping us in these efforts in the lobbying discussions did raise the very real possibilities that patients will figure out if they give incorrect information that helps them to kind of dodge the collection process for, unfortunately, those cases in which patients don't intend to pay their bills. So there's one more question about undeliverable mail, but I think what we'll do right now, since it's 1 o'clock, is we'll circle back and do a deeper dive on some of those issues with respect to the patient's information when they receive it, if it's undeliverable, if it was sent to the wrong address either by mistake or intentionally. We'll follow up with folks, and what we will do is the IMA staff can work with Kim to provide some expanded information and get that sent out to the group, similar to what we did last time we went through an Idaho Patient Act education series. So I just want to take this opportunity again, thank all of you, IMA, IMGMA, IHA members, for your support in helping us push through these changes. Thank you so much to Kim Stenger for your expertise in helping folks comply. And Kim, any parting comments on your end?
No, I know it's a pain. Unfortunately, that's kind of living in a democracy, right? The legislators got it passed, and IMA's done everything that they can to blunt the effects, and kudos to you again. If there are additional questions that any of you have offline, by all means, you can either use this chat feature and still submit it to me, and I'll get those questions, or you can shoot me an email, and we can respond offline or come up with our FAQs that IMA will publish.
Very good. Thank you so much, everybody, and please reach out to us with any questions. Take care.